What's the one thing in your life that you never, ever miss? If you could turn back time, what's something you did miss that you'd like to go back and make sure you never miss again? Jesse Jones from OLG's The Drive is hitting the streets. He's asking about the things that no one ever misses out on. You can follow the excitement as it unfolds online at globalnews.ca/The Drive. Brought to you by OLG. Sign up for a lottery subscription at playolg.ca and never miss a Lotto 649 or Lotto Max draw.
Story that we've been watching here in Toronto for years now. It seems like yesterday, but it actually was quite a while ago now. 2014, 2013? It was a while. But anyways, before I just ramble on anymore here, basically here is the word. The Supreme Court of Canada has rejected the appeal by the former Toronto Police Constable James Forcillo. James Forcillo, of course, convicted of this is a strange one, where he faced multiple charges for the same incident, where he was convicted of attempted murder in the death of 18-year-old Sammy Yatim. You will remember this, and this was, in fact, back in 2013, in July of 2013. Recapping kind of briefly what happened is that Sammy Yatim was a disturbed young man. He was 18 years old. He drew a weapon on a TTC streetcar and was waving it around. He was also waving his penis around, so he was obviously having some degree of distress. Everyone got off the streetcar. The police surrounded it, and the situation seemed to be contained. Constable Forcillo arrived at the scene, and within a matter of seconds, even though Yatim was the only man on the streetcar and the streetcar was surrounded by armed law enforcement officers, Forcillo approached the streetcar. There was an interaction, words spoken between him and Yatim, and then Forcillo opened fire, 2 volleys of shots. This is where the legalities of this get a little bit complicated. I want to bring Joe Neuberger on with me here, from Neuberger and Partners, one of our legal experts. Joe, the legalities of this were complex because there were 2 volleys of shots here. There was 1 volley of 3 shots that actually, according to the medical examiner, killed Sammy Yatim. He did not die instantly, but the wounds were catastrophic. They were not survivable injuries, and Sammy Yatim fell to the ground. There was an observable pause, and all of this was captured on video, and then there were 6 more shots. And it was this bizarre situation where he was convicted for that second volley of 6 shots because the court found that the murder was the first 3 shots, but that was justified. They said Forcillo, under the police rules of engagement, was legally justified in firing those shots. Maybe not ethically or morally justified. We can debate that. But the law was on his side on that one. But the court found that there was no reason for that second volley of a half dozen shots, and they ruled that as attempted murder because it wasn't fatal. It was one of the more interesting legal verdicts I've ever seen, Joe. And on the face of it, it actually makes perfect sense when you look at it closely. But if you take half a step back, it looks really weird.
Yeah, no, you raise an interesting point. It was a very astute move by the Crown when they presented the case to the jury. And in fact, they divided the 2 volley of shots into 2 separate transactions, which proved to be, an intelligent way to go about the prosecution. And you're right. When you take a look at it, it makes absolute sense because the first volley of shots was justified given the rules of engagement by police. And so one of those bullets was the bullet which fatally wounded Mr. Yatim. Mm-hmm. But then there's a period of time, I forget if it's 6, 7, or 8 seconds, and for inexplicable reasons, when Mr. Yatim is down on the ground, and obviously not a threat, and if you'll remember, this was on video, and then there was that explanation given by Mr. Forcillo that he perceived something and then said that he was wrong, given being confronted with the actual video of the second set of shots and what condition Mr. Yatim was in. That was an attempt murder because you can't kill somebody at the point who's already dead.
Yeah, and the thing is, Joe, as well, I mean, the constable, James Forcillo, had said that he thought after that first volley of shots, which we now know were fatal, he said he thought Yatim was going to get back up again, and that he remained a threat, and that's why he opened fire again. However, The medical examiner concluded that the fatal shot we're talking about here had basically hit the young Mr. Yatim in the spinal column and had destroyed it. The injuries were hopelessly fatal. They were non-recoverable injuries. He also wasn't getting up anytime soon because he was completely paralyzed by the shot.
That's right. So when the jury would listen to what Mr. Facillo gave as his explanation as to his perception and why he then shot another 6 times, the jury would look at the actual footage of what happened and would determine that that's completely unreasonable and reject the explanation given by Mr. Facillo because he was clearly on the ground and was not a threat in any way, shape, or form. So those 6 shots were gratuitous, unnecessary, and that's where they found that there was an attempt murder. So in the view of the Court of Appeal and now the Supreme Court of Canada not granting leave to appeal, it's fairly clear that this is a very strong and solid verdict.
What's interesting, Joe, and I'll get your reaction to this, there was a whole side drama to the whole affair here. Not that, gunshots on a streetcar and a young man cut down by a police officer, a controversial trial. I mean, you think all of that would be enough. But there was this whole secondary element to it where, Constable Facillo, Mr. Facillo now, he's no longer on the force, obviously. Mr. Facillo had been living in the community while waiting for his trial. During his trial, he was able to live in the community under strict conditions of house arrest, where he was supposed to be living in the home with his wife and his children under very limited release conditions. He could go out for a couple of appointments, but other than that, he was supposed to be in his home.
House arrest. Yeah.
Yeah. The problem, Joe, and you'll recall this, I'm just recapping this for the listeners, is that after the shooting, and this makes sense, I think people can understand this. This whole thing was very stressful on the marriage of the then Constable Facillo and his wife. They decided to separate, and Constable Facillo asked for permission to transfer where he was living his house arrest, to move it to a different address.
Right.
While this was being considered, a couple of police officers went to that proposed new location to do an inspection to determine whether or not it was a suitable environment for house arrest. And when they knocked on the door, James Facillo answered. He had already moved in without getting that judicial approval. He was immediately arrested. His house arrest was suspended. He spent the rest of the time of his legal odyssey actually behind bars. Joe, would the Supreme Court have considered that in making their ruling here? Like, what goes into them making their consideration?
No, that would have nothing to do with it. What they would look at is the merits of the appeal. And so they would look at whether the issues raised by the defense in their appeal factum have any merit as to this being a unreasonable verdict, or if there were legal errors made by the judge in the charge to the jury, or in the other arguments, because there was also an argument about the constitutionality. There was an application whether an officer should be exempt from the minimum punishments because of the fact that they have to carry a gun. So the court would look at the various arguments set out by the defense in the notice of appeal and the factum that they filed for leave to appeal and determine on those bases if there's any merit to it. The fact that Mr. Facillo had breached his bail in that manner would not factor in. And so they would just simply look at the merits of the appeal, and they've determined quite appropriately in the circumstances that there's no merit.
What would be, and Joe, in a very general sense here, you don't need to necessarily link it just to this case, the Facillo case here, but what would the court have been looking for? I mean, if they had an open mind to taking the appeal, what makes that determination here? What leads the Supreme Court to go, yeah, you know what, maybe we take a look at this again?
Well, there has to be an error of law, or, there has to be an error of law. That's really what they have to look at. And, when it comes down to it, what I think one of the main arguments of the defense was that this was, rather than dividing it into 2 transactions, this was one transaction. How do you really draw a distinction between a 6 or 8 second break in a fairly emotionally charged situation? And that, I think, was one of their main arguments. And the court has rejected that. The court determined that there is absolutely no legal error in this being divided into 2 transactions. There's no legal or factual error that raises any doubt as to the legitimacy of the verdict. And there was, the jury charge was appropriate. There were no errors. So the court will look at all those factors. The Supreme Court's not there to retry the case, nor is the Court of Appeal. That's not their job. They don't look at it and go, yeah, okay, this is interesting. Let's take a look at it. They have to find that there's an error of law. in order to determine, and an error of law that would have resulted in something different. I'm trying to explain this more in more layperson terms, would have resulted in a different verdict. So it's something that would have had a material impact possibly on the outcome of the case. And when they look overall at the facts which are laid out and the law which is laid out, they're going to determine and have determined that there's insufficient argument to suggest that there's any legal errors here that would have affected the impact of the evidence and on the jury rendering the verdict that they did.
Joe, thanks for coming on, and thanks for putting it in lay people's terms. I appreciate that. No, it makes perfect sense, right? Because, okay. I mean, just because an error occurs, humans are fallible, that doesn't mean the trial needs to be thrown out or done from scratch. The error has to be something that would have meaningfully impacted the outcome of the verdict.
Absolutely correct.
All right, Joe, appreciate this as always. Thanks for being on standby for us today.
My pleasure. Take care.
Take care. Joe Neuberger from Neuberger and Partners, one of our legal experts here at this station, and my guest moments ago here on The Exchange.
I just want to take a few seconds to tell you a really cool story. Back in 2006, Tim and Steve Beauchesne, they're a father and son, got together with a few friends and family and created Bo's Brewing Company. And right off the bat, they started brewing award-winning beer. In fact, their flagship beer, Lug Tread Lagered Ale, has won over 20 awards for brewing excellence. And Bo's has won over 100 awards for brewing, design, and supporting the community. Lug Tread is the original lagered ale, a hybrid style. Lug Tread is top fermented like an ale and then cold aged like a lager. It is crisp, balanced, and refreshing. Why not try it yourself? Bo's Lug Tread Lagered Ale is available at the LCBO, the beer store, and craft-friendly grocery stores. Please enjoy responsibly. Learn more about this family-run, employee-owned brewery at bos.ca.